Now, finally, as you can imagine, there are a lot of places where there could be issues. And so the California is actually one of the few states, and it's actually, at least it's surprising to me that not many more states have adopted this. There are states, certainly, but California is actually among the minority states that have adopted this. And it's called the harmless error rule. Now, prior to this, for the most part, the will formalities, because they're so susceptible to fraud and what have you, the statute of wills really came to really help that, and the statute of frauds really helped to reduce litigation. But at the same time, it reduced in litigation at kind of the cost of possible formalism. And so, you as you read through the cases, you'll see that there's really sad cases where there's some formalities not met. Maybe they only have one witness, or they have two witnesses, but one of them is interested, or what have you. And a lot of times, the witnessing requirement, which is intended to kind of protect and to ensure that valid wills get through, also could have the negative effect of valid wills not coming through because of some kind of error. So California has adopted what is known as the harmless error rule, and it's codified in 6110C2. This is actually a recent addition to the rule, so this is not something that's always been there, but I personally am thankful that it is there. I think that this will eliminate where otherwise sad cases where sometimes lay people just don't know what the requirements are, and they unintentionally fall error to that. Okay, but anyways, the harmless error rule says if the witnessing requirements are not met, and that's key, we'll come back to that in just a moment, then the will may be probated if the proponent establishes by clear and convincing evidence that at the time the testator signed the will, he intended the will to constitute his will. All right. So the harmless error, there is a lot of debate whether it applies to other places, but really the harmless error only applies to the witnessing requirements. At least that's the way it applies as written. It is C2. And if you read the probate code, it says that this applies to paragraph 1, which is the paragraph above, which is about the witnessing requirements. So a strict reading of this says that if the witnessing requirements are not met, then the will may be probated if the proponent established by clear and convincing evidence that at the time the testator signed, he intended the will to constitute his will. And this essentially is a harmless error to the witnessing requirements, okay? I haven't seen, although I'm sure there is, maybe I'm just not just privy to those kind of cases, but the harmless error does not seem to apply to the requirement that it be in writing, right? So the question is, could you use harmless error if someone made a video will? As far as we know, at least on the bald face, on the at least on its face for the probate code, it only seems to apply to the witnessing requirement. And so that's what it seems to do. Also, like the signature of the testator. Is the testator not signing harmless error? At least as the way as the probate code is written, it doesn't seem so. It seems to only apply when we have something gone awry in the witnessing requirement. So, and the evidentiary standard is clear and convincing. If it's been a while since you've been in Civ Pro, I like to think about the variety of burdens of proof by percentages. If you think about beyond a reasonable doubt, I like to think of that as 99.9%. And then there's, of course, by a preponderance of the evidence, which is more likely than not, which is 51%. And clear and convincing is about 75%. So if you're a math person and you like the rigidity of percentages, of course, that is not an actual percentage. I'm just trying to give you some something tangible to hold on to in terms of understanding how the burden of proof required to establish this harmless error. So clear and convincing standard for the burden of proof that he or she intended the will to constitute his will. And this is really intended to have otherwise ineffective wills or invalid wills under the probate code still be admitted to probate if there is something amiss with the witnessing requirement. So that's a harmless error rule. And I would have you check every single one of these boxes. So if you have a will on an exam or on my exam, take a look at it for its requirements. Ask yourself, can this is this will an attested will? If it's not an attested will, can it qualify as a holographic will? If it doesn't qualify for a holographic will, could the harmless error rule be used to essentially salvage the errors so that it can still be admitted to probate? Okay, so, and another key thing is it also applies to handwritten wills that would otherwise fail to meet the requirement of either an attested or holographic will. So handwritten wills, and like I said, that's more likely you're going to see that in the printing form. Let's say not all the material portions are in the testator's handwriting. So it's possible that if the proponent can establish by clear and convincing evidence that at the time the testator signed the will, he intended the will to constitute his will, then perhaps that otherwise ineffective handwritten will can still be admitted to probate.